To this presentation. For those of you who don't know me, I'm Gary Best. I'm a resident here, been a resident since 2015. I'm on a couple of committees, and if you've been around for a while and have come to the annual budget presentation for the last several years, I have done those as well. What got us here today is the board a while back created a new committee, the Contracts Oversight and Compliance Committee, and they asked me if I would be chair of that committee, and in a moment of delusion I said, sure, be happy to do that. And as we started to do our work, there were a couple of things for the committee that started to pop up, and one of them was, do we all understand the rules we live under here, the things we signed up for when we signed our mortgage papers to buy a house here? If you've ever lived in an HOA before, how many have lived in an HOA before? Okay. How many of you have plowed through these documents to see what goes on and how we're governed? Okay. More than I expected. My general approach to these things, historically, this is my third HOA community, is to say, yep, we got these governing documents. That's great. They cut my grass, they plow my snow, and they pick up the garbage. I am good. It's all I care about. Getting on the committees, it started to change things. There were more things to think about. And so one of the things we decided to do was do a presentation today. This is the first of at least two, where we're talking about how we're governed. What we can do, what we can't do. It's at a very high level. You can find all of these documents that I'm going to reference on the website. For those of you that may have a bit of insomnia or trouble sleeping, this is absolutely an outstanding read before you go to bed. It will put you right out, but it's also important. And so what we want to do today is cover these. The format will be, I'm going to take you through a presentation, through some slides, which will eventually get up onto the website, as will the video of this. And then at the end, we'll open it up for questions, and as best I can, I will answer your questions for you. So that's kind of how we're going to proceed, if that works for everybody. Okay, good. So HOAs in Florida come under two statutes of the state. And this is what enables us to govern, what enables the board to do their work. And basically it's Chapter 36, which sets up nonprofit corporations. And it is Chapter 40, which sets up homeowner associations. And it's under these rules in the state statutes that allow us to do the things we do. Without these, we can't do the things we do. We don't have any authority. But with these, the South Shore Falls Homeowner Association becomes a corporate entity. It can own property. It can make decisions. It can do things like that. These documents, the covenants, the bylaws, there's a couple of others that I'm going to touch on, were all established in January and February of 2004. Syntex, the company that started building South Shore Falls, put all of these together, filed them with Hillsborough County, filed them with the state, and that became the basis from which they could then start to build South Shore Falls as a homeowners association owned community. And so that's how we get here. And the documents are pretty clear in terms of, in order to have a development of an HOA, we need to set this up. The role of the homeowners association to own, operate, and or maintain various common areas and community improvements, to to administer and enforce the Declaration and other governing documents. And I've taken these verbatim from the governing documents. So if you look at, you can see up here I've got Article 1, Section 1.1. This is lifted directly. I'm doing no interpretation here of anything. It's coming right out of the document. We have a number of documents. When you go onto the website, you go into the governing documents section, you pull these things down, you are going to see a PDF that is roughly 125 pages long. It is all of these documents just sort of stacked together. And so the first, Declaration of Covenants, Conditions, and Restrictions. You will notice coming into our community that there's a lovely little sign that says Deed Restricted Community. And what that means is these declarations, covenants, conditions, and restrictions, among some other documents, govern what we can and cannot do. They're specific about what the Homeowners Association can do, as well as what individual homeowners can do. So on top of anything that Hillsborough County allows us or doesn't allow us to do, we've got these documents. So I live on the Loop. I'm in a sea spray villa. We like it a lot, but if my wife and I decide we need a second floor, the answer is no. If we want to extend our lanai beyond the requirements laid out in the ARC and some other documents, the answer is no. We're in a deed restricted community. And so that's the first thing we need to understand. There is a supplemental declaration. At some stage of the game, we bought some additional property. So if we want to buy property, we need to go out and do and file one of those things so that we can add to the community. Articles of incorporation. They create us as a corporate entity. Bylaws. This governs the operation of the board, among some other things. And this is specific because it talks about what the board can and cannot do and how the board doesn't. So they're a pretty important document. Our architectural guidelines, the ARC. These are the rules and regulations around what we can and cannot do with regard to our property. When this is put together, it was done under the auspices of Syntax and later Pulte, and they wanted the community to have a certain look, a certain feel. And so these are the documents that create that look and feel. If we play within the rules and regulations they outline, we're good. If we go outside of them, you get a letter from the board saying, you've gone outside these guidelines, we need to fix it. Initial use restrictions. These are interesting because they talk about things like where you can and cannot park cars. They're the driver for much of what's in the ARC. And they lay out the things we can and cannot do physically within the community. Board resolution and rules. These are requirements found in the bylaws. And it's how the board makes decisions, makes formal decisions. And so if the board wants to make a formal decision, it passes a resolution. And then that decision becomes formal, and we move on from there. These are key provisions in the documents. They're the next 3 slides. And I think the very most important thing here is the very bottom line. How can we amend or change these governing documents? And this gets a little confusing, but when you do a close read, what you learn is that we can only amend any of these governing documents with a 67% affirmative vote of all 866 shareholders. Every unit has an owner. That unit gets one vote, and for all intents and purposes, they are the shareholders of the South Shore Falls Homeowners Association. And so any change we made, we need to have an affirmative vote of 67% or 580 homeowners. Now the interesting part is, that means that there are 286 homeowners who can essentially say no. They can say no one of two ways. They can say no by voting no at whatever we're asking them to do, or they simply don't vote. In all cases, those are counted as negative votes, and we do not hit the threshold of 580 homeowners, so we cannot change the rules. And that's how we go about making any changes. It is a very, very stiff requirement. Centex originally puts that in because if you read the covenant documents, you're going to see two types of shares. Class A, Class B. We are Class A shareholders. A fancy word, the declarant, Centex Homes, was a Class B shareholder, the only one. And until they turned over the Homeowners Association to the community, which happened late 2015, early 2016, something in there, until they turned that over, they were actually the controlling vote for anything that happened in the community. They could say yes or no to anything we wanted to do. And under the way the documents were written, not a whole lot we could do about it. That is a pretty standard document for the builder when they're coming in and developing these communities. Because they don't want a group of homeowners coming in early on and deciding they want to change the mix of what the builder has decided. So we've got this kind of language that's incredibly restrictive. But that's how we make changes. As the owner, the association may exercise any right or privilege given to it expressly or by reasonable implication from the governing documents. So it's the homeowners. Now where it gets practical is how can we get 866 people, shareholders, to agree on any number of things? Frankly, it's pretty hard. So what happens is the governing documents and the bylaws identify the board of directors as the decision maker for the community. And they specify that on behalf of the community, the board of directors will make any and all decisions necessary for the maintenance, further development, continuation of the community. Now you may say, that's not so good. I don't like that. Problem is, and I'm not a lawyer here, so I'm getting out on a limb, but I'll go there anyway. I've been there before. The problem is, because we are a corporation, we are in point of fact not much different from Google or Apple or IBM. They all have corporate boards of directors. They all have shareholders. And those corporate boards of directors make decisions on behalf of the shareholders. They have shareholder votes for certain things, but as a corporate entity, it's vested in the board. And so we are no different than those entities. So our decision maker is the board. And, important here, except as otherwise specifically provided in the governing documents or by law, all of the association's rights and powers may be exercised by the board without a vote of the shareholders. It's to keep things moving. It's to make sure that if we need to pave roads or if we need to paint buildings, we can keep that going and we don't have to have long, essentially drawn-out conversations with somebody saying, well, I don't live on that street, I don't understand why I need to do that. So that's what this is all about. The Articles of Incorporation, another document, specifies completely that the association's business and affairs shall be conducted, managed, and controlled by the board of directors. Now, the board may delegate its authority, and we're going to get into that in a little bit. So the board can bring people on to help it do its duty. This is where the Contracts Committee got involved. This lovely little clause here. Subject to the contract terms, the board may modify or cancel existing contracts for services in its discretion, unless the services are otherwise required by the governing documents. The board is required to do certain things. The board is required to have insurance. It's required to maintain the common areas. It's required to have sufficient funds in the reserves. A whole listing of things that says, you can do all kind of stuff, but you must do these. And so those are just some examples of what we've got in terms of board responsibility that is declared in our documents. Next couple of slides are a list of general powers that the board has. Enforcement, payment of taxes, assessments, utilities, contracting for insurance around the common areas, contracting for goods and services that we need to maintain the community, power to set committees, preparation of budgets, financial documents, creating rules for the community's common areas, enforcing the initial use restrictions. So if you're in violation, we'll talk about this in a minute, there's something called the Covenants Committee and a Fines Committee. And these folks are the people who adjudicate anybody who's in violation. Saves us from running off immediately into the courts. But if you read the papers, you'll notice that homeowners associations from time to time do find themselves there as people dispute over what can and cannot happen. All of this is done to kind of hit what somebody suggested to me, and I like the phrase, was the prime directive. And in this case, as a corporate entity, as an association, the board is charged with making decisions that are in the best interest of the community as a whole. Now, the dicey part here is this may run counter to an individual homeowner who thinks that a decision they want made is in the best interest of everybody. And the board takes a look at it and says, sorry, this is not in the best interest of the community, this is in the best interest of you, and while we appreciate your interest, we're not going to do that, we're going to do something different. And the board is responsible, ethically and legally responsible for doing that. The other thing about this kind of community, and you'll find this in any community, but in HOAs it's more important, I think. And that is to maintain the overall property values. And the board does that in a couple of ways. It maintains the property, it maintains the common buildings, it maintains common areas, it makes sure that the community looks good. It also holds residents accountable for maintaining their little piece of heaven here, so again that the community looks good. The reason the board does this is, and we talked about this last year at budget time, but I think it's worth mentioning again. If you want to sell your house and you put it on the market, banks and mortgage lenders are going to come here and they're going to look at the community and they're going to ask some questions. Is the community maintained appropriately? Does the community have sound structures? Does the community have sufficient reserves to handle things that it needs to do? If the answer to those questions is no, then the lender has several options. It can offer a mortgage, but it will do it at an increased mortgage rate, interest rate. If it's really concerned about the community, the lender can say, we are not lending to this community. Any transaction will be cash only. Now, while there are people who can come in and buy cash only, and a lot of us may have done that because we've sold somewhere else and came in here and bought at a better price. If you can't do that, then you're not going to sell your property unless you find a cash deal. The problem with a cash deal is, in the realtors community, if they're trying to sell homes, and my realtor's bringing me through and said, this is a great property, you're going to love it, it's got all these amenities, this is just really spectacular. And oh, by the way, cash only. If I'm an astute buyer, I'm going to say, help me out here. Why cash only? Well, the banks have decided that. And if I'm a really astute buyer, I'm going to walk away. Which means we've got houses for sale that aren't going anywhere. The lenders are starting to cut us off. There's a snowball effect that happens here. The realtors then are reluctant to bring people in because of the conditions and requirements, and Renata is shaking her head over there. This, I'm sure, sounds a bit familiar. And so we lose value in the community. And that's something we don't want to do. The board doesn't want to do. We certainly don't want to do. But we keep value by doing all the things that the governance documents require us to do. And so we wanted to take a moment. Let's talk about how governance works for a minute. I'm getting a little bit ahead of myself. So we've got the Declaration of Covenants, Conditions, Restrictions for South Shore Falls, plus a number of other documents that were filed in January and February of 2004 that lay out how we do this thing. We've got the South Shore Falls homeowners who, as the South Shore Falls Homeowners Association, own the corporate entity, own the Homeowners Association. We've got an elected board of directors that has power, rights, and responsibility to make decisions in the best interest of the South Shore Falls Homeowners Association. The board may appoint a management company to help them with this, running the day-to-day affairs of the community, and most boards do this in communities our size. The board may also appoint and create those committees that it believes will help them run the community. And they ask for volunteers from the membership, from the owners, to come and sit on these committees. The role of the committees is to be responsible for a certain piece of work. Architectural Review Committee looks at any applications to change anything on the exterior of your house. Covenants Committee interprets the covenants, adjudicates any disputes we have concerning what the covenants mean between the board and a homeowner. Contract and Oversight Committee, this is brand new. This was created to take a look at our contracting process, at our contracts, and see if we can get the best contracts available to make recommendations. All of these committees make recommendations to the board. None of our committees have decision-making power, but we do have power to make recommendations to the board over what we should do with regard to architecture, changes we should make, what we should do in terms of contracts, what we should do in terms of keeping the ponds fresh and clean. That's the role of these committees, to become experts in that area and help the board make decisions. The board pools all this information, turns around, goes down to the community manager and says, manage our community according to the directions we give you. That's what we want you to do. And so that is a very high-level look at our governance structure. So, I have talked a lot. That was the high level that we wanted to kind of lay out for you so that you could have a better understanding of how this corporation works. And now what I'd like to do is open it up for questions that you may have and see if we can, meaning me, since I'm up here with a microphone, can provide answers. Janet?
Who actually is on this board committee? Do you have names?
We do have names. We were in a bit of fluctuation, so we didn't get out there. We will get the names up on the website. Let me tell you what we did do, because there's a number of them, and I am lousy with names. Sorry. We've got a number of folks, 4 or so attorneys or retired attorneys, some business people. Renata is a realtor, she's on the committee. We wanted to have a really nice broad section of people who may have touched contracts in the course of their working lives, so that we could look at contracts in a way that made sense. So we also wanted enough people that if a bunch of contracts hit at the same time, we weren't all going crazy and turning into full-time workers. So we have enough people that we can create small subcommittees to handle multiple contracts if they roll up. We're working on a number of ideas around helping the board with contracts. And we're working off the idea, and I might as well put that out there now, that given what we think of as the contracting environment here in Hillsborough County, we think, we're still looking, but we think it's in our best interest if we can create long-term, mutually beneficial partnerships with various contractors so that we can have continuity, so that we can have no surprises in terms of pricing for some period of time. And so that's sort of our philosophy and kind of what we're working off of. Is that a decent answer?
Somewhat.
Somewhat. But you really want to know who's on the committee? Well, I was tap dancing as fast as I could. Let me see. There's me. There's Renata, Ed Block, Wayne Arnold, Hart Fisher, Larry Maverick, Greg Thrash, Randy Duckworth, and 2 or 3 more folks. Some of them joined the committee and are snowbirds, so they promptly joined and decamped for Regions North, and so they have not been as actively involved as some of the folks who are here. But there are 2 or 3 more folks.
Every committee has a representative from the board and a representative for the contracts itself.
So on all of these committees, every committee has a board liaison. And the board liaison is there to represent the interests, the intent of the board, so that we as a working committee understand what the board is going for. It also helps, I think, a little bit on a very practical matter that we don't have to attend every meeting that's held by everybody to keep in the loop. It gets us a little bit of flexibility. But there is a board member that sits on every committee.
Are there terms, like a year, 2 year?
appointed and then they're on there as long as they want to? And is there a number that's only allowed on there?
Yeah, I think the short answer to this is, depending on when the committee was created, there may be more regulation or more of a defined charter than when later committees were created. So so specifically to answer, there are not any formal guidelines or regulations around how long somebody will stay on a committee. The other issue we have is getting people to serve on committees. This is not actually the easiest thing, and many of us kind of come down here and they say, well, you know, I put my 35 years in the trenches, I banged it out every day, and I am going to play golf. Thank you very much, I'll see you later. And so it gets a little bit tough to bring people on. I think my own view, Gary Best's view, is more structure would not hurt and might help. But we also seem to have some reasonable self-regulation on a number of our committees where people are saying, look, I've been here for 3 or 4 years. It's time for some new ideas and some new people. So there is some self-regulation, but there's not a lot formal. And the bylaws speak to the board. They do not speak to the committees created by the board.
Will it be your committee's function to go out and get bids for certain contracts, or you leave that up to the candidates here? You actually go out, so for instance, like if your AC contract is coming up for all the buildings here,
Yeah.
you will get, your committee will go out and get actual bids.
I think right now, we're new enough that we have not worked that out yet. What we do, though, is talk to the board and say to the board, or the board will come to us and say, we think we need to go out for a bid. Okay, great. You guys go out for a bid. We will then look at the bids that come in. As the board makes decisions about the bidder that they like, we'll start to turn around language in the contract that is protective of the community and mutually beneficial to the community. And so right now, that's kind of where we're working. I think as we evolve over time, that may also change. But the fact of the matter is we're pretty new and things are moving pretty quickly.
Will there be, will your group be the group that communicates actual terms and conditions in like lay terms? For example, if our landscaping contractor does not do tree trimming anymore like they used to, would your group be the one to say, hey, according to our contract, this is what they're going to do for us. The other things we're going to communicate to you, we'll get another vendor to do that. Is that the kind of...
Yeah, as a matter of fact, what we're working toward is a collaboration with all of the committees. So landscape is a good example. We've got a landscape committee, and in an ideal world, their role is to help the board determine the kind of landscaping we should have here. We will rely on them to convey that to our committee. We want to become experts in contracts, not experts in landscaping. So we are going to draw on committees, pond committee, landscape committee, that have expertise and say, what should we be doing here? They'll give us something in writing, or we'll have a meeting, we'll capture the notes, we'll go out for bid, or we'll go to an existing contractor and say, we like the work you've been doing, we want to keep you, let's talk about next steps. They'll put in a proposal, we'll turn around, add the phrasing that we think best protects us, or corrects something that went wrong in the past. We will then recommend to the board, this is the contract we're recommending. At that stage of the game, as you well know, it becomes a negotiation.
So you request bids, or do you request proposals?
That's an interesting question. I think what we may start, we've requested bids, we can request proposals. It depends on the size of the contract and how complex the contract is, or how complex the work is. And so we're feeling our way through that. We're also, and I'm getting a wee little bit ahead of myself here. I wanted to save this for the next, the next presentation, but what the hell. Hillsborough County is in a significant growth spurt. If all you gotta do is ride down 19. A lot of houses are going up, a lot of them are HOAs, a lot of the contractors are going to get to a point where they're gonna be able to pick and choose where they go. And so we wanna make sure that we've got relationships that have them pick us, as opposed to saying, well, we've been with you guys for a couple of years, frankly, you're a pain in the can, you're on your own. We really don't want that conversation. And because of the build here and the expansion, we're concerned that that might be a possibility. And we don't know if we can fill that possibility or not. I mean, there are people out there that do the work. But if I've taken my company and grown it and I'm as big as I want to get, maybe I don't want to pick up one more client. Maybe I don't want another community. And we've got to consider that. That's got to be a factor in our deliberations.
Yeah, when you sign a contract with a vendor, within that contract, are there any standards and requirements or performance measures that they have to abide by? And is it who controls that from our side if the vendor is in breach of it?
Yeah. So the answer is sometimes. The going forward answer is we want those things in there very specifically, and we want them in there clearly, and we want to be able to measure the performance of whatever vendor we bring in here. And frankly, I don't know, has anybody here dealt with corporate contracts? Of course, sometimes you bring a vendor in, and sometimes we measure not what's important, but what's easiest to measure. And that's not a good thing. That leads to problems. So we're trying to identify for each contract things that are appropriate to measure, necessary to measure, and that we can measure. And then we want language in there that holds the contractor accountable.
I've been involved in the other end of the contract, being the user of the many years. And to me, and in my business, the user tells in this case, the board, what they want measured, what's important for them. So, you mentioned landscape or the pond committee or whatever. If something is, us, the community, feels that this vendor needs to do 1, 2, 3, 4, 5. This is what, it should not just be what the contract committee or the board can measure. It has to also be, part of that has to be what's important to the user, to us, the community. So the board may not think, trimming that tree is important, but to us, it may be trimming that tree is important. Okay? There has to be some sort of a combination of thought between the user and the board. So when these vendors are chosen, the community and the contracts are written, the right information is in there so we can then truly hold them. And the user, being us with all our work orders or whatever, that's the measurement of whether they're doing a good job. How quickly do you respond to a work order? How is the work order communicated? Okay, to the submitter, and all things like that. And there has to be some sort of someone responsible for looking at that. Maybe it's another committee, maybe it's part of the contract committee, maybe it's part of the board, but somewhere, someone has to be identified to review the performance of our.
Yeah, so a couple of things. This is one of the things we're going to talk about at our next meeting. See, you guys are pulling me out of this meeting and you're sending me into the next meeting. It's very disturbing because I like my PowerPoint decks. But having said that, there is a clear recognition that some of our processes, systems, approaches to managing the contracts and getting work done in the community has not been particularly effective in certain areas. We get it, we all understand that. So part of what we're now working on is ways, whether it's processes, whether it's systems, whether it's a work order system that's better. We're working on pulling those together because we understand we need to figure this out. There's no, I mean, nobody's questioning that, nobody's saying that this is perfect. We need to figure it out. And we also need to make transparent to the residents what is and what is not in a contract. We need to make, so I'm going to give you the next slide in my next PowerPoint deck. If you would all visualize this with me. You've got a graph. Bottom of the graph is community's willingness to pay. Vertical side of the graph is contractors' willingness to provide services. At some point in there, there's a sweet spot that says, we're willing to pay X. Contractor says, I'm willing to provide these services. We need to figure out what that is. The conflict is going to come, and it will come, when we have residents who say, I want more services than what the sweet spot indicates. At that stage of the game, we've got to find a way to resolve that. But that's what we're trying to figure out. That's what the contract committee is, as we consider and deliberate on contracts, trying to figure out is your willingness to pay, their willingness to provide a certain set of services, where do they meet? What's that intersection?
But I'm asking, but once that point is reached, once you reach that intersection and it's agreed, the contract's agreed, someone within the community has to hold that vendor accountable to
Got it.
what we've already agreed with. All that's already been done, we've agreed on this, we've agreed on X, now you have to provide X or else
Got it.
there's a consequence.
So the first line of defense is going to be the community manager. That the community manager is going to go out, check on what's going on, and manage the day-to-day affairs of the community, which includes the vendors. Second line of defense, if the community manager is having issues, as I understand it, going to come to the contracts committee, we're going to involve ourselves and say we've got a problem here. Third line of defense, if we can't fix it, is going to be to go to the board with recommendations on how to repair it. Each step of this, very particularly once it gets to the contract committee, very particularly once it gets to the board, is going to be a negotiation with whatever vendor we're having issues with. But we understand that we need to strengthen and bolster those steps. They've got to be clear, they've got to be well understood, and everybody's got to kind of be on board. That answer your question?
Oh,
Okay, I'm trying.
I'll come to the next meeting.
I'm watching our president over here. I'm trying to see if there's daggers coming out of his eyes, or if he's saying, "Oh, yeah, okay."
John will just stick his dog out.
Any other questions?
Yes, so the contract's in place, and like you said, you've already signed up, everybody's agreed, contractor's gonna do ABC, we're good with that. And it's a 3-term or a 3-year contract. How often is the property manager gonna be required to pull that contract and actually review it and go back? I mean, because I think that's a lot of what's happened. We've signed off on the contract, contractor's in here for 3 years, and all of a sudden, a year in, they're more or less doing what they want to do, and they're not doing what the contract has been written up and required. So how often are they going to do that? Every quarter? Are they going to do that every 6 months? Are they going to wait a year and a half in?
First of all, that's an excellent question. Second of all, we've got roughly 17 contracts. Some of them are really big, some of them are really small. So I think for the really big ones, we are going to have to be very clear with the property manager and include it in their contract, those sorts of things of what we expect with regard to review of contract, review of success. Well,
I know, like with Kathy Sabrito was here and stuff, that's kind of.
yeah, so let's talk about that. As long as there was a Class B shareholder it made no difference. The community manager wasn't actually managing much of anything. The project manager for the builder was managing much of everything. So as that changed, you know, things had happened, and they just sort of happened. And then all of a sudden they're gone, and now things aren't happening, and we're asking why. And so part of the growth and learning process of us as a community was to understand where we had to bolster or step in and redo processes that were actually being handled by the builder, and they weren't frankly telling us much of what they were doing. They were just taking care of it, which was great about taking care of it, but it wasn't helpful for us in terms of governance. And so we are learning.
So actually, that kind of fell through the system when we as a community took over and the builder stepped out. And the property manager, I guess, was at the time,
They were
wanted their contract, and so are you?
They were brought in by the builder.
Right.
See, I understand the builder wanted to be able to build, do what he needed to do, and they didn't want a lot of grief from it. So we bring people, the job was to build and sell houses. And by the community manager, because we're supposed to have one, the community